Hey, your old buddy Brian Parker here. Just did a class action video and I wanted to follow up with another reference to one, meaning what this really is about is a cool statute that covers federal service members and their spouses. It's called the Servicemembers Civil Relief Act. And what that is, a law designed to protect against financial consequences or ramifications of service members that go into the fray, or they're overseas, or they're just being put forth either into state National Guard or to federal active duty. And what that is designed to do is to get rid of the things that you and I, that weigh us down every day about paying bills and keeping ahead of the game and covering our monthly expenses. The military wants its members to focus and not be worried about what's happening with their wife back home, or their mortgage, or their car payments, or suffer repos. And that makes sense. The Servicemembers Civil Relief Act, let's put it up for you, postpones or suspends certain civil obligations to enable service members to devote their full attention to their duty. It makes sense. Wouldn't we love that, to just be able to fully attend to our job that's really we're doing to pay our bills that weigh us down, whereas those poor guys are taking a pay cut, and gals are taking a pay cut to defend our right to be at our desk or do this video. So they're protected from with outstanding credit card debt, mortgage payment, pending trials. We're going to talk about that. Taxes, termination of leasing. When I say termination of leasing, they're covered on both leasing of cars and leasing of homes, and life insurance protection. It covers all active duty members, reservists, and members of the National Guard while on duty. Remember I said that as far as state rights are concerned. It's called the Servicemembers Civil Relief Act, SCRA. I've done some cases in that vein and they're fun. The purpose is 50 USC APP.511. It was amended a couple of years ago. The purpose of the act is to provide for and strengthen and expedite the national defense through protection extended by this act to service members of the United States, to provide temporary suspension of judicial and administrative proceedings and transactions that may adversely affect the civil rights of service members. Keep in mind, and I have a client right now whose husband is active and they're going through some things, and I've got him out of that, and she is a military spouse. And it is so the military member and their spouse does not have extra worries at home and can focus on the mission. Now, when I was in the Army, especially basic, I'm sounding like an old guy, gray hair, but they really beat the crap out of you. They made it so that you mentally and physically could withstand a lot of nonsense, at least during infantry. It's infantry basic training, so that they knew if you were going to flip or break, they had to break you then, so you wouldn't do it to your your team when you're actually under fire. I say that because one of the ways they would break you is you'd go on these runs, or they'd constantly be, the drill sergeants would be in your ear about Jody is going to take your girl. Jody this, and Jody got your gun. Jody got your girl. There were no Jody protections, is my point, like they are here for the mental welfare of the service member that is now active and doesn't want to be plagued by financial problems at home. And that, as I was studying and learning about this, I could have used some Jody protection, because that's what they constantly did to you. If you look down on the ground, they'd say, ain't no use in looking down, ain't no discharge on the ground. It was just a mind F, if you will, and it really served me well in law school. Anyway, let's put up the following who receive protections that I didn't with my Jody problem, and especially as it relates to collection lawsuits. So, Shazam, active military members of the Army, Marines, Navy, Air Force, Coast Guard, members of the Reserve, members of National Guard, and active duty commissioned officers of the Public Health Service or National Oceanic and Atmospheric Administration. Again, these also apply to spouses, and here are the protections of the SCRA. Reducing an interest rate on any pre-service loan to a maximum of 6%. Protections against default judgments in civil cases. So that's where I see it all the time. A service member is overseas and then learns that their house is being foreclosed. I've had those cases. Or they got a default judgments against them and they're over in, I don't know, they're in a certain place and they're calling me to help. So I got to go in, and I've used the SCRA. It is very good. The minute it's one of those things where if a lender or a bank hears that, or the attorney, it's over. It's your magic button to press. So it's nice. I like representing vets, especially those that are active, because my trial head goes immediately to trial, and having him there, her or him in their dress blues, sitting on the witness stand. And it's over. It's not getting that far. In my settlement discussions, I go, well, I'll just have my client come in her dress blues and see how the court likes it, every motion at every pretrial. So why not? They're taking a pay cut and they're risking their lives. I know I did. I had benefits that I got, but I had to get through the active duty part. So they should be protected for our sake. So a lot of this I'm going to depend on the CFPB website today, but let's look at the reducing interest rate to 6% part. If you took out an automobile, a home or student loan, and I guess that would apply to Fed and private student loans, or incurred credit card debt, or any kind of loan jointly with your spouse, because spouses just go through the same crap that their military member husbands or wives go through. I've seen it all. You're allowed to have your maximum interest rate reduced to 6%. It's for pre-service obligations applied during the period of active duty for most loans or mortgages. In addition, after a year later, after the end of active duty service. A lender can't revoke your loan or credit account or change the terms of your credit or refuse to grant you credit just because you exercised your SCRA rights. As a side note on that, student loans, federal student loans, went through this moratorium just after COVID hit, and everybody stopped making their payments by federal rule, and no interest rate and all that. And I expect I'm going to get cases. I think it was after September of 2024 when all the student loans are required to be paid again. I bet you there are banks, companies, whatever, that are putting the interest rate they couldn't charge or the payments that were missed into the new payments. And I'm just waiting for those cases. I know it's coming. But that moratorium should have stopped the clock ticking on the interest rate. Let's see what happens. A lender can't furnish your negative information to a credit reporting company. Remember that class action case? I was talking about how they were threatening, if you don't pay in 20 days, you will be marked on your credit. Well, the SCRA, as far as members of the military are concerned, are protected. Now, by the way, as you're going to see soon, the protections they have doesn't mean all is good. You're going to see a very interesting lawsuit coming up about, even though these federal rules are in place, the bank said, yeah, but he's not paying. And they went ahead and violated the rules that, trust me, they're fully aware of, okay? Default judgments, that's the collection law context. If you're sued while a service member on active duty, you have certain legal protections. Before the court can enter a default judgment, the party suing you must file an affidavit with the court stating whether or not you're an active military duty. So if you get defaulted, you'll see on the forms, this person's not a military active duty. They'll also say, and is not disabled mentally or otherwise. And there's no way, like when there's a specific database that you can, let me put up on the video right now what debt collectors do before they, sometimes you'll see this in your lawsuits. Shazam, and that's the Department of Defense Manpower Data Center. And that's where debt collectors go either when they initiate a lawsuit, this sheet is on lawsuits all the time, or when they're about to do a default against you, a default judgment, they have to check a box saying, we check this. They also have to check a box saying you weren't mentally incompetent or disabled or a 6-year-old at the time they got the default. There's no database like there is with the military database showing incompetence. So my litigation brain always looks at that and goes, there's no way you check that. You can't. You checked off the box that you did. You signed that under oath. So I'm always looking for ways to beat stuff, and that's a good way, but I digress, as I normally do. If you're active duty and have not appeared in a case against you, the court may enter a default judgment, may not enter a default judgment until after it appoints an attorney to represent you. That's nice. So you have a right to criminal attorney representation. Here in a civil case, you may get an attorney to represent you. That's giving me an idea. Anyway, I'll talk about that later. The court also has to permit a delay of proceedings for at least 90 days if certain conditions for the member are met. I've done a number of these cases. Active military, I love the dress blues, or even just the fatigues sitting there. We love our military members, and we should, right? I'm naming this, the thumbnail that I use to excite people's viewership is going to be, as it is, it's thank you for your service. Here's a lawsuit. So this prevents lawsuits while you're active, foreclosures, losing leases on homes or automobiles. You have great protection almost a year later in some cases when you're an active service member, and you should. Guess what? Each state can add to the protections already enjoyed and employed for members. And if you think about it, it makes sense because the federal National Guard, if you will, are also open to a state governor employing them for state use. Like a hurricane comes in, knocks out Florida towns, and it gets really bad, so they get the National Guard in. So they're now working for the state per se, but they're federal members. So each state can add, like here in Florida, let's put one up, Florida, ba-boom. Service members with mortgage obligations entered into prior to being called to active duty, state or federal, cannot be foreclosed upon by the lender during the time of active service if it's more than 17 days or within 30 days thereafter. So that's nice. Let's put up Alabama. Yes, Alabama. If a service member dies while deployed overseas, the lender must wait at least 180 days before starting a foreclosure against the surviving spouse. That's nice. Or the service member's estate, provided that the surviving spouse or the estate notifies the lender and asks for a delay. Well, at least I got something in Alabama there. Let's look at Illinois. No, let's look at good old Michigan. That's one of the states I practice in. Shazam. Michigan law provides special protections against foreclosure to certain military service members. These include members of the Michigan National Guard. If a service member entered into a mortgage before becoming a service member, or the mortgagor, you are the mortgagor, the bank is the mortgagee, the lender cannot obtain a non-judicial foreclosure during the service member's period of military service. It's important that you know in Michigan, they have a non-judicial foreclosure statute, meaning they don't have to go through a judge, which drove me crazy because we're supposed to expect everybody to fly right and do the right thing without the judge looking over things. And as you know, as I talked about yesterday, 2 days ago in my class action, I found a cool way to mess with banks, mortgagees that are foreclosing on my clients under the FDCPA. And that was the basis of, as I said, of a friend of mine's class action. And that was because in Michigan, there's a non-judicial foreclosure statute, meaning all they have to do is put something on your door, tell you there's going to be a sale, and then be a sale, and then they give you 6 months to redeem the property, meaning come up with the chunk of money that it sold for. By the way, at the sale, only the bank was there to bid, and surprisingly, they bid as much as you owe. So that's not the case in some states. They have judicial foreclosures, but Michigan is looking out a little bit for consumers there as far as its National Guard. Illinois, boom. In addition to the provisions of the SCRA, as I told you before, no state can limit or minimize the federal statute. If you want to get into the 14th Amendment, state versus fed, all that stuff, but it's a federal law, so you can provide additional protections to your state members. Certain active duty members of the Illinois National Guard may apply to call for a 90-day stay of foreclosure proceedings. All right. Let's go a little bit down south a bit. Kansas, let's see what you got for us. Shazam, none. Mississippi, none. Mississippi has no state law distinguishing the provisions of the federal SCRA. How about Missouri? None. I got the cat. Just don't do that. So Missouri, Mississippi, Kansas, you got to take better care of your veterans. So that's brought to you from the SCRA state law website, Servicemembers Civil Relief Act centralized. So this brings us to an interesting class action as I end this video. Okay, check this out. Have you noticed how many commercials are on TV now? I think it's USAA Bank, let's call it that. And it's Ron Gronkowski, who, interesting acting. And then Sam Elliott's terrific. And so supposedly these very rich guys have to be roommates. And the point of the commercial is Ron is, of many commercials, Ron's not a member, a service member. And he's like, can I still get to be a member of the USAA? And that's the silly commercial. And they allow him in for whatever reason. So they're running these ads for the last year or two. You saw them in the Super Bowl. But USAA, which is looking out supposedly, they were initially just as a bank available for only military officers, not even grunts like I was. But then that umbrella lengthened and more people were protected if they were service members by USAA. So now they're advertising non-members protection. I wonder why. So we're going to find out. Here is a class action by service members against USAA for the following reasons. These are allegations filed in 2021 for a class action. So remember we talked in my class action video, nothing is a class action until the judge signs off. Well, the judge signed off in 2024 and the parties agreed to settle. Remember, there's a couple of ways to settle a class action. The parties usually agree, or there's a trial, or there's just because of the class certification, it forces the parties to decide who is eligible. They come up with money numbers, case is gone. So The defendants were accused of marketing to service members as a bank dedicated to military members. You've seen the commercials, veterans and their families. They breached their duty to America's fighting forces by charging interest rates and fees that were too high. Remember, you have to reduce it to 6%. They charged more, and it's alleged that they allowed unlawful charges to improperly inflate the service member's principal balance. So I did a lot of reading on this, and they were sending account statements out, but they weren't showing any basis of why money was owed or whether an interest was. They just sent out the same account statements, even though they are alleged to have charged more. And then it goes on, the class action. Defendants concealed their overcharges from thousands of military families victimized by their practices and other class members who did not discover that defendants were violating their rights until 2021, when defendants sent misleading correspondence and payment checks to some military families. It's alleged that when USAA got caught, they then went and filed and sent checks out. But they sent them, they sent them out in nondescript envelopes that look like junk mail. What do you do with junk mail? You throw it away. So they, I guess, could say, well, we sent them checks, nobody cashed them, but they purposely made the envelopes, it's alleged, so they were perceived to be junk, and nobody cashed the checks. So this lawsuit was filed in a class action with a proposed class under, as we talked about, Rule 23. All persons at any time on or after, check this out, September 11th, 2001. I wonder if that was an accident that the plaintiff's attorneys chose that day. All persons at any time or after September 11th, 2001 who received reduced interest or fee benefits from defendants on an interest-bearing obligation because of obligor's military service, but excluding persons who have executed a release of their rights claimed in this action. So anyone that received benefits from this defendant, USAA, also there's a subclass, a Florida subclass, meaning they're also riding on the Florida improvement of the federal statute. And that member is defined as who at any time during the class period were residents of the state of Florida while receiving reduced interest or fee benefits from defendants. So let me give you quickly what was alleged. The first named plaintiff, remember, in this case, there were 4 or 5 named plaintiffs. The first gentleman was Philip Bowles, a member of the Army Reserves, and during repeated periods of active duty, he has had numerous interest-bearing accounts with defendants, including credit cards, automobile loans, consumer loans, and home equity loans. They provided him with an interest rate and fee benefits under the SCRA. That's nice. For example, defendants provide him with an interest rate of 4% during active duty. And since he has left duty, he's taken out debt while enjoying those benefits. However, again, they hid what they were really doing in their account statements. Defendants failed to reduce the interest rate and waive the fees as required by the SCRA. So they were advertising, hey, come on board. We're going to give you all these military benefits, including the reduced rates under the SCRA. But as his monthly payments and correspondence showed, he received misrepresentations that he was being charged the correct interest rate. And the misrepresentations in defendants' monthly bank statements caused him to stay at that bank, to join that bank, to bring all his business that he would have otherwise not done but for the fact that this bank advertised, we'll get you covered under the SCRA, and then they didn't, and they are alleged to have hid it. So he paid more in interest rates and charges on accounts with defendants that should have been due under the SCRA. So that was the subject of a class action against USAA, who are advertising now that now non-members are covered. So if non-members are not covered, they don't enjoy the benefits of the SCRA. I wonder why they're doing that. Anyway, according to the military.com website, the 4 plaintiffs allege that banks did not lower interest rates or fees in compliance with the Servicemembers Civil Relief Act. The banks then concealed their overcharges with thousands of military families, and despite their representations of plaintiffs and other class members, defendants failed to comply with the SCRA. So there was a multi-million-dollar settlement where the judge approved each plaintiff receiving slightly more than $200, that's every member of the class, with the 4 named plaintiffs getting an estimated $20,000 each. So, as I talked about briefly yesterday, you're entitled to up to $1,000 under the lost class action I filed under the FCCPA, but you can negotiate with the defendants to be paid anything as named representatives, and that's always my goal. When I represent someone as a class rep, I'll ask them to be the class rep, and I said I'm going to try hard to negotiate getting more than the statute allows. So the attorneys with the plaintiffs, Smith and Loney, PLLC, God bless them, Hagens, Berman, Sobel, Shapiro, LLP. Remember yesterday I talked about solo practitioner like me, or my friend in his case, they'll take on other law firms to help finance the hard part, which is mailing the notice. They have requested 27.5% of the settlement, or more than $17 million. If a judge signs off on that, then he's done the hard work and investigated so that the pool of recipients of all this $200 per receive this without coming out of their money. And it's got to be reasonable and necessary. And as I said, under most fee-sharing statutes, you're entitled to attorney fees and costs from the defendant, not the pool of money for the poor members. So when you watch those commercials with Rob Gronkowski and Sam Elliott promoting USAA Bank, it used to be they would talk about very recently that, come on, military members, as happened here. They were promoting the benefits of the SCRA to come have you join USAA, or USAA Bank. Do I have the complaint? Yeah, hold on, because I'm really being not doing a good job for you here. The defendants are USAA Federal Savings Bank and USAA Savings Bank. So now you have a perspective as to why they're now expanding with Rob Gronkowski, a non-military person, telling people, hey, you too, non-military, can be a member now, because they don't have to offer these protections or get gigged if they do something. That's an opinion, or maybe they're doing it because they're just expanding their business, whatever. But they have a settlement now that shows that their members of the military clients faced several misrepresentations, according to military.com, including when they were sending them checks to make up for the mistakes. They put it in envelopes where you didn't know what you're getting, and they didn't correspond with the members. Like, hey, this is to pay for what we kind of made a mistake with. So that had to be paid for, and the members also received benefits for uncashed checks. Anyway, so that's a look at the SCRA. It's USAA. All right? And they're just doing business, but they got caught here with their hand in the cookie jar. I'll attach the class action complaint to this video at KillDebt.com. You be the judge. I'm not making an opinion as to why they're doing their advertising that they're doing now. The commercial, without a doubt, is rather silly, because Rob Gronkowski and Sam Elliott would not be roommates. Thank you. Hope this wasn't too silly. Bye-bye now.